As the headlines get nastier, a new word has started bubbling up in the comment sections and TikTok deep dives: malpractice. Did someone's lawyer drop the ball so hard it cost them the case? Or is the internet just doing what it does best, playing armchair attorney without a law degree? If you've been following the It Ends With Us fallout, you know the drama didn't stay on the press tour. It migrated into a courtroom, and according to a recent deep dive by the legal analyst known as Little Girl Attorney, there is a massive difference between a bad strategy and a legal crime. So, before you go calling for anyone's bar license to be revoked, let's pull back the curtain on what's actually happening behind those mahogany doors. Because as it turns out, the mistakes you think you're seeing might actually be calculated moves in a very expensive game of chess. In the world of law, calling someone a bad lawyer is a Tuesday, but calling a peer's work malpractice? That's the nuclear option. As Little Girl Attorney pointed out in her recent breakdown, accusing another lawyer of malpractice, especially when you are a lawyer yourself, is considered the height of being unprofessional. It's not just a mean comment. It's potentially damaging to a person's career and reputation. Lawyers' words carry weight and authority, and throwing that weight around recklessly is a quick way to lose respect in the industry. Legal malpractice is a legal conclusion. It's not a vibe. It's not a feeling. It's a claim that requires a very high bar to be met. To prove it, you have to show that the attorney was acting completely out of their depth, basically that they were so incompetent they didn't meet the basic standards of the profession. When you look at the Lively versus Wayfarer case, we aren't dealing with amateurs. There are 20 to 30 top-tier lawyers involved across both sides. These aren't people out of their depth. These are the heavy hitters of entertainment law. So, if they aren't incompetent, why did certain claims get tossed out of court? Is it possible the failures we see are actually intentional? One of the biggest frustrations for fans following this case is the why. Why didn't Wayfarer's lawyers amend the complaint? Why is the Lively side scorching the earth with sanctions motions? From the outside, these look like errors or overaggression. But Little Girl Attorney offers a dose of reality. The attorney-client relationship is a black box. When we sit in the comfort of our homes scrolling through court PDFs, we are only seeing the final output. We aren't privy to the thousands of hours of strategy sessions happening behind the scenes. For instance, if a lawyer decides not to amend a complaint, it doesn't mean they forgot. It often means the client and the attorney weighed the risks and rewards. Think about it this way. Would you spend $100,000 of your own monopoly money to chase a claim that only has a 10% chance of winning? Probably not. Wayfarer might have decided that defending their name was more important than spending millions to sue Blake Lively and Ryan Reynolds for specific damages. Every move, whether it's a scorch-the-earth tactic or a quiet withdrawal, could be driven by fee arrangements, client demands, or a hidden long-term strategy. But if the strategy wasn't the problem, then why did the judge dismiss Wayfarer's claims against the Hollywood power couple in the first place? There is a common misconception that Wayfarer lost their claims against Lively and Reynolds because their lawyers didn't know how to file a proper lawsuit, specifically the group pleading issue mentioned in the Rule 11 motions. The claims weren't dismissed because of a typo or a filing error. They were dismissed because of legal privileges. The court decided that certain statements and actions were protected by law, meaning they couldn't be sued over, regardless of how well-written the complaint was. In fact, if the judge hadn't ruled on those privileges, the court likely would have given Wayfarer another bite at the apple, a chance to rewrite and refile the claims. The fact that they didn't get that chance isn't a reflection of malpractice. It's just the reality of how a judge interprets the law in high-stakes litigation. It's easy to judge from the sidelines. At the end of the day, law is as much an art as it is a science. Every lawyer has their own flair, their own objective, and their own style. Some lawyers are sharks. They want to win by overwhelming the opposition with motions and sanctions. Others are diplomats. They play the long game, looking for a settlement that saves face. Neither approach is wrong or malpractice. They are just different tools in the toolbox. Just because you would do it differently doesn't mean they did it wrong. Both sides in the Lively versus Wayfarer battle have excellent representation. They are fighting a war where the stakes are reputation, millions of dollars, and the future of production companies. They are making the best decisions they can with the information they have, information that we, the public, will likely never see. The Lively versus Wayfarer case is far from over, and as more documents are unsealed, the armchair attorneys will surely have more to say. But as we've learned, the line between a bold strategy and malpractice is a mile wide, and the experts aren't ready to cross it yet. What do you think? Is this legal battle a necessary defense of creative rights, or has it devolved into a scorch the earth campaign that's gone too far? Drop a comment below and let us know your thoughts. If you found this breakdown helpful, share it with your favorite pop culture junkie.